Thomas has had to log off. So Thomas has had to log off because I think he's got connectivity issues. 1 more minute while we get him back on. But yeah, thanks everyone for joining us. To get Thomas back on. Hi, Thomas, are you all good now?
Yes, thank you, and apologies for that. Technology issues, I got kicked out. I hope I'm audible now.
No, you are audible. Thank you for joining us again. I'm going to kick it off now, just with just an introductory of our talk, and then of course to also introduce you. For brokers that don't know me, there's a little bit of an echo. Okay. Nick, can you also please mute yourself? Thank you. So for brokers that don't know me, my name is Fiso. I head up the PI team. And today we just want to chat to you guys or to brokers regarding professional indemnity and in the attorney space and the functionality of the LPIIF, which Thomas will go into detail with. So what iTOO's role is in the attorney space in general is that we offer top-up cover to the LPIIF, and we'll generally stipulate that the LPIIF deductible is applicable. So our policy is comprehensive and it includes extensions that may not be covered by the LPIIF, such as your loss of documents and misappropriation of trust monies. Thomas is going to go into detail with what these are and where his cover starts and where his cover ends. And then what we generally require for cover is we will send you a legal practitioner's proposal form for completion. We will also request a CV to indicate professional qualifications from all key members, as well as a valid fidelity fund certificate that will always be requested up front. We also will want a bank verification procedure, and how that will work is that when attorneys' clients request a change in banking details, generally there should be a process followed to ensure that the instructions are coming from the correct client, and that the attorney has validated and authenticated that the instructions are coming from the client as well as professional fees that have been earned from the rendering of professional services or the rendering of advice. So those are generally the requirements for coverage. I'm going to introduce our speaker because I don't want to waste any more time. Please just bear with me while I here. So Thomas is one of our speakers today, and he is he has a Bachelor of Arts and Bachelor of Laws degrees and postgraduate certificate in risk compliance and governance from Wits University. He was admitted as an attorney in 1997 and practiced for more than a decade. He joined what is now called the LPIIF, then known as the AIIF, in 1999 as a claims manager. He has been the general manager of the LPIIF since 2011. His functions at the LPIIF include serving as the head of risk management control function. He is responsible for the company's enterprise risk and operational risk relating to the legal profession. He also serves as the general legal counsel and conducts all high-risk litigation and litigation involving novel legal points. He develops the legal arguments advanced and testify on behalf of the company in court and at tribunals. He teaches risk management to legal practitioners and writes articles on the subject monthly. His job also includes working on policy wording and benchmarking the policy against similar policies locally and abroad. His stakeholder engagement functions include representing the company in various structures locally and abroad. So I will hand it over to Thomas now. Thank you. And I'm going to stop sharing.
Thanks very much, Fisokuhle, and good morning, colleagues. I'll just bring up the presentation, and I just got to correct a mistake that I made. I joined the LPIIF in 2009, not 1999. My boss always tells me that even Bart Simpson, even Homer Simpson sometimes loves his lines. Don't know, is the presentation visible on to your side?
Not yet. Not yet. If you can share, if Shazia can please share it for us, because I did also send it to Shazia.
Yes, thank you very much for that. I'll take you through a rather whirlwind tour of the LPIIF. I've tried to include content that's relevant to brokers and to the insurance market, and hopefully we'll give you some just a few matters to think about over and above understanding the LPIIF a little better.
Okay.
So I'll just wait for the presentation to come up. And as part of what we'll present today, I'll just give a brief explanation on just some of the structures in the profession, including the Legal Practitioners Fertility Fund, what is the fertility fund, and what the LPC is, the Legal Practice Council is, and what the various roles are. Because from the 1st of November 2018, when the Legal Practice Act came into effect, there were fundamental changes to the structure of the profession, and just sometimes I think from a top-up perspective, some of the policy wording hasn't really kept up with the changes. And in saying that, I haven't seen iTOO's current policy, so that is just a general remark. Thanks. If we could please move to the third slide. The next, just some numbers for you to consider, so that you can understand the context in which we operate. You see, as at the end of December, there were almost 32,000 practicing attorneys, and they were arranged into almost 19,000 firms. That will give you, from a top-up perspective, it's the size of the market. From our perspective, we see it as the size of the risk pool. And we had, that's not a typing error, it's 2,222 claims, which a value of over 722 million. That is a significant amount in anybody's language, more especially for us as a small insurer with that operates on a non-profit basis. And in respect of our other line of business, we had, that's executor bonds. We had bonds with an outstanding value of 4.8 billion. And as we move to the next slide, please. The LPIIF was established by the Fidelity Fund in 1993. It's that's an important point, because a lot of people in the profession, a lot of people in the insurance market have adapted different narratives over the years. And the truth, the one narrative is, the one truth is that this company was established by the Fidelity Fund in 1993. Who the company doesn't have shareholders. It has one member, which is the Fidelity Fund. It's a non-profit company. It's registered with as a short-term non-life insurer. We write two lines of business. One is liability, that's professional indemnity. The other is executor bonds, which is a guarantee business. We provide professional indemnity insurance to all practitioners with Fidelity Fund certificates. That's attorneys, and from the 1st of November 2018, it's also the advocates with the Fidelity Fund certificates. Because from that date, there was a new line of practitioners that came into the picture. That's the advocates with Fidelity Fund certificates. Some call them trust account advocates, what are called Section 34(2)B advocates. I think our presentation has disappeared.
I'm trying to get it back on. Please just bear with me.
I'll just make a few points while we do it with the LPIIF covers all. Please move to the 4th slide.
Okay.
Apologies for this, colleagues.
Is this the one?
Yes, thank you. And okay. The LPIIF covers all those practitioners with Fidelity Funds certificate, and without this cover being in place, cover in the top-up market would be much more expensive if the commercial market was writing cover from the ground up. The reality is that we sit closer to the fire. The vast majority of claims are paid by the LPIIF. This makes TI insurance for the legal practitioners cheaper in South Africa, whether you compare it with other professions, or even if you compare it with other countries. And one of the questions I often pose is whether there'd be appetite and capacity in the top-up market to write the entire risk pool in the absence of the LPIIF. When I speak to insurers, to insured practitioners, I put it differently. A lot of them would be uninsurable in the commercial market because they'd be too risky, or only insurable on very adverse terms. Next slide, please. Okay. Just some differences between the LPIIF and commercial insurers. We carry out a specific legislative function set out in Section 77 of the Legal Practice Act. Commercial insurers exist for commercial reasons. We are non-profit. Commercial market operates on commercial terms and thus make a profit. Cover is provided under the LPIIF policy automatically, as long as the practitioner has a Fidelity Fund certificate. In the top-up market, you apply for cover. Because our cover is provided automatically, there's no broker or intermediary, whereas in the top-up market that applies. And just like to make a point there, we often get queries from brokers wanting us to wanting renewal forms for the LPIIF cover. There are no renewal forms, as long as the practitioners have a valid Fidelity Fund certificate. And then I see someone who says, oh, okay, I thought there was a problem with the sound. In the top-up market, you undertake an underwriting process. We don't, because the legislation says we must cover everybody. The insureds do not pay a premium, because a premium is paid on their behalf by the Fidelity Fund. And then also we issue one master policy annually. Our insurance year runs from the 1st of July till the 30th of June. In the top-up market, you renew annually. There's no need for run-off cover as far as the LPIIF is concerned, because even if an insured leaves practice, as long as on the date that the cause of action arose, they had a Fidelity Fund certificate, we'll still cover them. There's an annual limit of indemnity on our side. Cover is provided per claim in the top-up market. We pay defense costs in addition to the limit of indemnity, and it's included in the defense costs are included in the top-up policies. Those are just some of the differences. Okay, please move to the next slide. Just the Fidelity Fund. The primary purpose of the Fidelity Fund is to refund third parties, usually clients, who've suffered losses because of theft of trust funds or property and entrusted to legal practitioners. It's a client protection fund. That's important because some people think that it protects the attorneys. It does not protect the attorney, it protects the client. And it's a fund of last resort, meaning that the client needs to exhaust all their rights against the attorney first before they can approach the fund. And it's important to note that in terms of the Legal Practice Act, if there's an insurance policy, in this case, a misappropriation of trust fund policy or a guarantee, that policy or guarantee must respond first before the Fidelity Fund does. Last year, the Minister of Justice gazetted a cap of 5 million rands per claim for claims against the Fidelity Fund. Before that, claims were unlimited. Just in terms of numbers, the Fidelity Fund is sitting with about 1.2 or 1.4 billion rands of outstanding claims. That will give you an indication of how many theft claims there are. In addition to paying, to refunding clients who've lost money as a result of theft, the Fidelity Fund also makes an annual appropriation to the Legal Practice Council, that's the regulator, towards the funding of its, in order for it to carry out its funds, and it also pays for the legal education. And as I've noted at the beginning, some of the wording of the top-up policies doesn't correctly capture the functions of the various structures. For example, I've seen policies that say that if there's a dispute about whether an activity falls within the conduct of the profession, they'll go to the president of the law society. There is no president of the law society. The 4 provincial law societies ceased existing on the 1st of November 2018. So I think when you speak to your colleagues in the top-up market, please look at that. And then there's another body that's often just thrown in the mix, the Law Society of South Africa, the LSSA. That is not a regulator. It's a professional interest body. It says it carries out a trade union function. It's not a regulator now and never has been. Thanks. Please move up to the next slide. Just briefly, in respect of claims, in the last, well, since this company started, there have been certain areas that have been high risk. RAF work, number one. RAF work, it's generally prescription. If these are claims reported that are reflected on the site, if we are to look at claims paid, 58% of the claims we pay are prescription related. This is despite us spending a lot of time with the profession, teaching them about what measures can be implemented in order to mitigate the risk of prescription. Conveyancing has been a problem since 2007. Went through we dealt with a lot of bridging finance claims between 2007 and 2011. We've had cyber claims that crept in. And the reasons for the high number of conveyancing claims have also been documented. People being overly reliant on paralegals, people being overly reliant on the conveyancing software packages, not properly checking instructions, just not looking at at the basics. Litigation is also very high risk. And if you look at just those high risk areas, a lot of them are conducted by smaller practices. And more than 60% of the practitioners in South Africa are sole practitioners. So you see where the risk lies. When it comes to matters like commercial matters, it's not a problem of, it's a problem of severity rather than frequency. What I mean by that is that there are less commercial claims, but in terms of value, they are higher than the other claims. Then, if we could please move on to the next slide. And this is just a picture for the last year, which shows that's 2023. It shows a similar picture to what has been happening on over the last 5 years. So claim types, claim progression patterns are really very stable. Next slide, please. Just in terms of how the LPIIF provides its limit of indemnity, it's based on the number of partners or directors in an incorporated practice on the date that the cause of action arose. You'll see there, it's a sliding scale from sole practitioners, the 1,562,500, all the way to larger practices, 14 partners and above the 3,125,000. In anticipation of the question of when we intend raising our limits of indemnity, the limit of indemnity will remain the same for the coming year. The average value of claims that we deal with is 800,000, falls within the retention. And raising the limit, and I hope I don't get kicked out for saying this, will really benefit the top-up market rather than the insured. It means so. We feel that our limit is still adequate to cover the claims. And then on the next slide, we have the...
Sorry, Thomas, can I just ask a question on this?
Yes.
So from my understanding is that you issue individual fidelity certificates for each member, right? Does that mean that they each have 1.5 million, or as a firm, they have the combined 1.5 million limit that you've shown here?
Thanks, so as a firm, they have that to 1,562. It's not per individual. And also the fidelity fund certificates aren't issued by us, they're issued by the Legal Practice Council.
Yes.
But your question is something that even people in the profession often think that each person has 1,562,500. That's not the case.
Perfect.
And then on when it comes to even our deductibles are based on the determined by the number of partners. So just on the number of partners, unfortunately, there are law firms that do bulking. So every year when they want to get onto panels of organizations, they just add people on as partners and call them whether it's salaried partners or so forth. That has got nothing to do with us. And in fact, there's a judgment that was delivered in July last year. I could share it if anybody's interested. The South African Legal Practice Council versus Sherwin Incorporated, that said that so far as the Legal Practice Act and the Companies Act are concerned, and insofar as liability, there's no distinction between a salaried partner and an equity partner. So please be careful of that with your clients, those people that decide to bulk up. And also BEE fronting is a reality. Those people have to pay higher excesses because the excess is determined by the LPIIF says, the policy says, actual partners are those held out to the public as such. And I think your point, the Fiso was addressed in that last bullet. It's an annual aggregate amount for the firm and not per individual direct. Next slide, please.
Okay.
And these are the excesses payable. You'll see that in column A, it's a higher excess for the high-risk areas, RAF work and conveyancing claims. Please ask your to read what we publish. We put a lot of work into that to help them mitigate risks, but unfortunately, there's still a big part of the profession that doesn't read it. We also, we've really tried to assist practitioners, but those are the applicable accesses. Next slide, please. So how do we manage risk? First of all, prescription, because it's such a huge problem. We have the prescription alert system. It's a computerized diary system. Practitioners just register, they register, and then they can register all their matters. The system will send them periodical reminders of the looming prescription date. There's a common misconception that this applies to RAF matters only. It doesn't. It applies to all areas of work. I don't know what the experience is in the top-up market, but with us, if you look at an area like competition law claims arise because the practitioners doing that work missed deadlines. So even competition law matters can be registered there. We published the risk alert bulletin and also articles in the practice management column of the Rebus monthly. There will be an article that will be uploaded later today. Don't even remember what it's about because that's just the amount. I write 10,000 words a month, and we try and make it practical, so they're not theoretical, hoping that practitioners can read it. We also offer risk management education at no cost to firms around the country. Please ask your clients to take that up. It will help you manage your risk. This service is free of charge. We travel anywhere in the country. Our philosophy is that it's cheaper to travel to see a firm than it is to pay a claim. We also conduct the PMT course, the practice management and training course. That's for attorneys who have been promoted to be directors or partners, or those that are starting their own firms. They have to undergo a PMT. We teach that. Last year, I taught over 3,200 lawyers in that, hoping to get the risk management gospel through. We also litigate a lot, either in our own name or by subrogation, on matters relating to liability. We had a huge win on the 20th of March, where your clients will tell you that they face difficulties with the RAF introducing new measures for the acceptance of claims that increase the risk of prescription. We took that matter on in our own name and fought it and were successful. And we'll continue that fight if it goes to the Supreme Court of Appeal or to the Constitutional Court as well. So could we please move on to the next slide?
Okay, before we move on, can I ask about the risk alert bulletin? Is that available to everyone, or is it like public, so that our brokers can also be able to access that information?
It's available to absolutely everyone. Please look at on the LPIIF website, on the risk management page, you'll see a link there to the risk alert bulletins. So Perfect. It's available to absolutely everyone, and you can search. You'll be able to see by the topics if there's anything that's of interest to you. And I think if you want more information, for example, on this presentation, if you look at the May 2022 risk alert bulletin, answer the 10 frequently asked questions. So it will tell you what the LPIIF does, and we cover everything: cyber, supervision of staff, all sorts of topics. So everybody's welcome to have a look at it. And
Perfect.
slide, please. So cybercrime. We got the first notifications of cybercrime related claims in about 2020. And over the years, those have increased as business email compromise spread. And as I stated earlier, two risks that we've covered a lot, that receive a lot of attention, are prescription and cybercrime. Cybercrime related claims have been excluded from our policy since the 1st of July 2016. And the next bullet is just a concern that I need to raised with our brokerage colleagues in particular. Even though we spent a year before the talking to the insurance market and to the profession, before this change came into effect, we still get notifications from brokers of cybercrime related claims. And I don't know whether what the issue is rather unflatteringly referred to it in an article as I wrote as sausage mentality of some people. But if a claim, and in my email when I was invited by iTOO to address this, I gave an example and said that if a claim is excluded at 8:10 on a Tuesday and it's still excluded at 8 minutes past 11 on the Tuesday, surely on Wednesday at 11 minutes past 11 it will be excluded. And that wasn't just something I just wasn't a thumbs up. I looked at actual claim notifications. Brokers just keep sending these claims to us, even though they're excluded. It's the same with misappropriation of trust fund claims. You see as at the end of December, we had 174, just over 174 million rands. Those are rejected claims. Conveyances are the main targets, but in the last few weeks, we've been informed by the profession that the cyber criminals are now trying to get into RAF, to get into their hands on the RAF payments. Please ask your insured to read what we've written there about measures that can be implemented in order to mitigate this risk. And ask your insured please to read what the rule says, Rule 54.13. It's a rule that says that prior to making the payment, the firm must take adequate steps to verify the bank account details provided, and any change of banking details must be similarly verified. That's in effect is what practitioners just aren't doing in that. And something for you to think about, colleagues, because you sit on the other side. Practitioners tell me that when I address them that they cannot get cyber cover in the market, as say, but there's cyber cover available. There's plenty of cyber cover available as far as I'm concerned. And then others say, oh, but it's very expensive. And I ask if they've ever, can they show me a quote just to get an indication of what it costs, what they are buying for their premium. Needless to say, nobody sends that to me. So I'd like you to think about whether you are getting any a flood of queries regarding cyber cover. And just on the issue of cost, I'd say that I would rather pay 60,000 if I go back into practice tomorrow. I'd rather pay 60,000 rands to an insurer for cyber cover because it will be their problem. 60,000 rands is less than paying one claim or the cybercrime claim. So I think that they should look at it. If we could please move on.
Just to comment on this one, Thomas, before we move on. So from what we understand is that our brokers will first notify the LPIIF of any claim from an attorney, and then report that to the top-up market. So perhaps maybe that is the reason why you get an influx of claims that perhaps don't have anything to do with your policy, because I think the market understands that you have to first notify LPIIF and then the top-up market. Can you comment there, maybe?
They notify the primary layer and the top-up if it's a professional indemnity claim. If it's not a professional indemnity claim, it's not a claim covered by the primary layer, you don't. If when insured vehicles are stolen, do brokers notify us? They don't. So they don't really. It's a risk to first of all, it's a huge administrative burden on our side. Secondly, in the time that you are communicating with the LPIIF, there's a risk that there'll be late notification when it comes to the insurance.
The top up.
Yes, when it comes to the top up, sorry, because sometimes there's toing and throwing, and you have to phone brokers to explain it. They say that they weren't aware of this, and so it's really there's always a risk that they'll notify late. So I think that if brokers also read their LPIIF policy and understand what it covers, that will assist them.
Perfect. So I think that's the reason for this session as well. Okay, cool. I'm gonna move on.
Yeah. Just on this rule regarding verification. 96, you see the 96.5% of members of the profession say that they are aware of the requirement to verify payments, so the payment details before making the payment. That statistic is drawn from the responses to the LPIIF's risk management questionnaire, which I'll come to. My question is, if almost 97% of practitioners are aware, are allegedly aware of the requirement to verify payments, I don't know why we are still having so many cybercrime claims. So I'll leave it for you to decide how honest people were in answering that question. If we could go on to the next slide, please. And you'll see more than 97% have responded that they are aware of the risks associated with cybercrime, but then they get shocked when they are hit with cybercrime. Once again, I'll leave it for you to decide how honest people were in answering that question. Next slide, please. And this also related to cyber risk. 33% of well, almost 34% of the profession say that they have cybercrime insurance in place. I'll leave those to you colleagues in the commercial market to make up your mind. I've given you the numbers of professions of firms in South Africa. You can do your own calculations to see whether there are almost 34% that have cybercrime covered. Next slide, please. Just some notes for brokers and the top-up market. First of all, get a copy of our policy on our website. We also stipulate when claims should be notified to the LPIIF. So to your point with the brokers, sometimes, and these are in the very small minority, we have matters that are reported to us late because they ensured there was a lot of toing and throwing with the brokers, and the broker didn't know that the LPIIF exists. Generally, we aren't as strict as the commercial market. We still accept the claims, even though it's notified late. Please look at the exclusions, the cybercrime I've mentioned, as well as theft of trust funds. I've also mentioned, because those are particular problems for us because they're just keeping notified to us. Also, the LPIIF doesn't issue certificates of insurance. We have brokers that ask us for confirmation of cover. We do not, and the reasons for that are also set out on our website. We do not know who our insured are. The first interaction we have with them is when they notify us of a claim. Remember, I said that insureds don't apply for this cover. As long as they have a fertility fund certificate, they are automatically covered. And related to that issue of certificates of insurance is the last bullets there. So that a lot of attorneys look for certificates of insurance when they are applying for tenders. And perhaps the colleagues, you would be able to look in your own time how many people purchase top-up just because they want to meet the minimum requirements and then don't renew their policy. And I'm glad that the top-up market also asks for fertility fund certificates, because Practicing without a fidelity fund certificate is prohibited in terms of the Legal Practice Act. That's also something that we took all the way to the Supreme Court of Appeal just for clarity. And fidelity fund certificates must be renewed annually. We have a team here at the office that works with the Fidelity Fund that deals with that. Today is the 2nd of April. People were supposed to have renewed their Fidelity Funds certificates from the 1st of January, but there's still a big chunk who haven't done that. So please, I don't know whether you ask for the Fidelity Fund certificates with every renewal, but if there are problems, for example, a lot of those people that haven't had that, they're 4 months overdue with their Fidelity Fund certificate. It's because sometimes there's a problem with the Legal Practice Council that there are complaints against them. They could not get a clear audit on their trust accounts, and those are issues. I think if you are selling misappropriation of trust fund cover, for example, should be should raise the red flags for you, that those practitioners may have problems. And then annually, we ask practitioners to complete a risk management self-assessment questionnaire, and that's where some of the stats come from. That's compulsory both in terms of the policy as well as the requirements for applying for a Fidelity Fund certificate. We had that built into the rules. But the questionnaire poses a number of risk-related questions, and you'll see from the examples I've given you with the responses to the cybercrime-related questions that some of that information, some of the responses are really questionable. And I always wonder how those questions compare to what people put in their proposal forms to the top-up market, and whether the top-up market asks for a copy of the risk management questionnaire that has been submitted. The law firms complete that. Each partner completes it in a firm. So those are your insured risk-related information. I don't know whether you ask for that. And we've often wondered, but we don't have the information, whether people try and paint a rosy picture for us, and I don't know whether they do the same with the top-up market. I won't get into what the position will be if I said something in the LPIIF's risk questionnaire and said something else in my proposal. But
so, if I can,
Carol, please.
If I can comment on that, because the PI and the cyber are two different policies, we generally don't get to see what they submit to you guys versus what they submit to the cyber market. So that's the issue that we have. But it's great to note that you actually are asking these questions up front and practitioners are answering them. So I think perhaps once we have a combined offering, which is the PI and the cyber, that information will come in handy. Definitely.
So if you could please go onto our website and download a copy of that risk questionnaire. You'll see it covers everything. It covers PI, it covers cyber, it covers what areas of practice how the fee split is made up. It covers what internal measures they have in respect of supervision and all risks. So it covers all risks effectively. And we've made it compact, so it's not a 30-page document. In many instances, we've just asked yes/no questions and allowed people to add some comments. So, but please look at it for all your offerings.
Perfect.
So, and then we also just some questions, and I know that we rushed through this because I'd just like in the last 12 minutes to answer some questions from colleagues and not let this be a monologue for an hour. That's our website, lpiif.co.za. Please look at the risk management page for the risk alert bulletins. In the practice management column of Darebus also, you can access that free. You can even subscribe to it. for the free of charge, and it's really, there's a lot of risk related information there, claims trends, what we see, the direction of things going in the legal profession. We try and get as much information out as possible. But thanks, colleagues. I know that was speedy. I know that we rushed through it. If anybody wants to communicate with me, that's my email address. And yeah, if there are any questions, I don't know whether you want to highlight any questions from the chat, and then I can address those in the remaining 11 minutes.
No problem. I'm just going to go into the questions. Sorry. So we've got one question. It says there's constant pressure for attorneys in some firms to maximize fee earning time and increase billable hours. Do you think that this contributes to burnout and possible errors made on the part of the practitioner?
Short answer, yes. And we've also written about this, about the pressure cooker environment that attorneys find themselves in. When I started, and actually I think today's my anniversary of my working here, when I started on the 1st of April 2009, and the old Glenrand, there were 18,000 attorneys in South Africa. Now there are over 31,000. The legal profession has grown in that time, but the cake hasn't. It's become more competitive. And after 2020, with COVID and some firms having to downsize, a lot of those went to open their own practices. So they're chasing money, chasing billable hours, chasing work, and so that, which means that they need to take their eye off the ball. And because lawyers, and I'm also a lawyer, so nobody can criticize me, I hope, are seen as sort of superhuman and see themselves as some sort of superhumans. They don't take care of their own mental health, and that leads to claims. If you were to ask, and I know the Australians have done a lot of work in this regard, if you ask the Australians sit down with lawyers and ask them what went wrong in a claim, and they say often you'll see that there were other things happening in the attorney's life. So yeah, that's a long answer to say that yes, that there is a problem with burnout and the increased cost of practice and all that. Sorry, the next question, why does the LPIIF not offer cover to attorneys in practice as NPCs? I don't know what that's, non-profit companies. Attorneys can't practice as non-profit companies. In terms of the Legal Practice Act, as well as the LPIIF policy. In terms of the Legal Practice Act, attorneys in the commercial market can only practice as sole practitioners, as partnership of practitioners, or as or in incorporated practices. That's Section 34 of the Legal Practice Act. Note the next question. We cannot proceed with applications to strike off an attorney for misconduct or being a vexatious litigant. That's striking offs are within the purview of the Legal Practice Council as the regulator, and issues of being litigious, vexatious litigants, that's for the parties to deal with. Don't know, any other questions?
There was one. So there's one that says, what does the claim procedure entail? Should the client institute legal action against the practitioner first in the event of prescription or negligence, and thereafter the practitioner must notify the LPIIF, or can a client merely claim from the practitioner without summons or notify the LPIIF?
Yes. Thank you very much. It's something that that's a question that also comes up a lot when I deal with the profession. All that's necessary is if the client were to say to an attorney, I'm unhappy, you didn't handle my matter properly, I'm going to go and see another attorney and claim loss against you. That's is an intimation of a claim. The attorney can notify that to us. There's no need for the clients to issue summons. If a client writes a letter, whether they write it themselves or go to another attorney to write the letter to say that you did not carry out the mandate correctly, the client has lost money, and therefore you are liable. That's enough to trigger cover under the LPIIF policy, and that's what we want. And in fact, we want the notifications as early as possible. If you look at a conveyancing claim, for example, we had one conveyancer that was did a property development on the eastern side of Pretoria. He realized that he made an error 96 times. When he picked that up and told us about that, we said, it's fine, rather than wait for the other 96 people to claim and for the banks who issued bonds to come after you, we'll rather spend 50 or 60,000 rands going to court to rectify that. So we didn't wait for the claim. And 50 or 60,000 rands is less than paying 2 million rands for a claim. So as early as possible.
Perfect. I think that was all from the question side. If there's nothing else, Thomas, if you could please share any future insights that you see in the profession, any trends maybe that you're projecting for the future so that we as the top-up market can be ready for what's coming.
Yes, thanks very much, Fiso. I certainly will. Think we've just ended the first quarter of this year, so I'll wait for some of the stats to come out. Also look at what is happening just in the stats from the profession, and I'll try and put something together, and I will share it with the market. And I also take this opportunity to thank iTOO and to thank all our colleagues who have joined. I know that in the commercial market, you are out there chasing money. Don't mean that in a bad way, but you've got clients to service, you've got income targets to meet, and you've come and listened to me speak for an hour. I really appreciate the opportunity, and I hope that there was something useful that I gave you, just one useful nugget.
Definitely. Thank you, Thomas. Thanks, everyone, for attending. Yeah, this is the end of our session. Thank you so much.
Thanks, everybody. All right.
Bye.